Hello, everyone, and welcome to today's webinar presentation, an insider's view of the EEOC, recent and current strategies, litigation, settlements, and what's on the horizon. Although we're in a presidential election year, employers should not expect a slowdown in actions taken by the EEOC. During today's event, Littler experts Jim Paretti and Barry Hartstein will cover major issues of concern to the employer community, highlights from Littler's annual report on EEOC developments, and noteworthy settlements, charge activity, and litigation filed by the EEOC. Before we get further into today's topic, I would like to take a moment to introduce myself and my organization. My name is Stephanie Zielinski, and I am the Marketing Director of ComplianceHR. You may recognize my name from the invitation emails that you received for today's event, and some of you may even have emailed me directly about this presentation. To prevent a few popular questions from entering the Q&A box today, I would like to let you all know that this presentation will be recorded and you will receive an email containing the recording and a link to view the slide deck. So please keep an eye on your inbox for an email from ComplianceHR webinars. Now, a bit about ComplianceHR for anyone who may be unfamiliar. ComplianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler. ComplianceHR delivers expert employment law guidance in a fraction of the time that you would otherwise spend with traditional methods. Our goal is to simplify the complexity of employment law, something we will learn a lot about during today's presentation. To achieve that goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics, like employee handbooks, employee overtime classification, independent contractor evaluation, onboarding, leave, and many others. However, today I would like to briefly introduce you to our two most popular solutions, PolicySmart and the Reference Center. PolicySmart is a comprehensive employee handbook solution that provides you with federal and state compliant templates, a compliance policy timeline, handbook checklists, and even sends automated emails to alert you on new legal changes going into effect across the U.S. The Reference Center is a solution that combines key employment law and HR compliance topics such as final pay, workplace posters, predictive scheduling, FMLA, minimum wage, and many others. Created to help HR, legal, and compliance professionals do their jobs more effectively and efficiently, this solution leverages data directly sourced from Littler to ensure compliant answers to your critical questions. If you're interested in learning more, a survey should have popped up on your screen about a slide ago. You may have to exit full screen mode to see it. If you would like to receive a demonstration of the Navigator Suite tailored to your organization's concerns and risks, simply answer yes, and I will send your contact information to our team of experts. In addition to a demo of our solutions, you may be eligible to receive a free trial of our products so you can see precisely how much time and money they will save you. While I let the poll run for just a moment more, you may be wondering how our solutions fit in with today's topic. PolicySmart supports HR and employment law professionals with jurisdictionally compliant policies for the areas in which your organization operates. Further, our unique policy effective date timeline clearly shows not only when policies will go into effect, which gives you and your team time to implement them, but also which policies require a mandatory update to your employee handbooks. Additionally, the Reference Center provides critical HR compliance information, breaking topics down into easy-to-interpret subtopics, and it even allows you to compare jurisdictions side by side to ensure compliance with even the most stringent local requirements. So again, if these solutions sound like they would streamline your organization's compliance strategy, please select yes on the survey. Now I have the pleasure of announcing today's expert presenters, Barry Hartstein, Littler shareholder and co-chair of the EEOC and Diversity Practice Group, and Jim Paretti, also a Littler shareholder with the Workplace Policy Institute and core member of the EEO and Diversity Practice Group. Barry, I will pass it over to you.
Thanks a lot. Good afternoon, good morning, as the case may be, to all of you. To help get all of us on the same page, we're going to look back over the next hour on developments in the EEO field, particularly focusing on EEOC developments and related EEO developments, going back the last 12 to 13 months. we've really witnessed real dramatic changes in the EEO field. We've seen 3 major Supreme Court cases we're going to be talking about. We've seen updated guidance on harassment. We've seen new regulations dealing with the Pregnancy Workers Fairness Act. And so the bottom line is we have a lot of ground to cover. You obviously, I'm Barry Hartstein, so you can hear my voice. And so, Jim, speak up so they recognize your voice.
Good afternoon or good morning to everyone, depending on where you're joining from. Looking forward to a very full hour today.
All right, let's turn back to the agenda. There we go. We're going to start off with some insights on the commission itself, particularly discussing key reports as well as related statistics. We're then going to turn to the topic of harassment with specific attention to the EEOC's guidance, which was issued on April 29th. Next, we'll turn to the Supreme Court's April 17th decision in Muldrow versus the City of St. Louis, which really changed the applicable standards for actionable claims under Title VII, and discuss the implications of that decision. We'll also briefly review the potential impact of the Supreme Court decision in Students for Fair Admission versus Harvard and North Carolina, and its impact on diversity, equity, and inclusion programs. We'll then turn to what I'll call the triple play of accommodations, the new rules dealing with pregnancy accommodation, ADA accommodations, and the key issues that remain front and center, and the changing standards applicable to religious accommodation based on the Supreme Court's decision in Roth versus DeJoy. And then we'll finish off with the session with some discussion of AI and pay equity. Not to suggest that those are any less important than anything else we're going to be talking about today. All of you are going to be receiving an electronic copy. Aside from the slides themselves, you're also going to get a copy of Littler's annual report on EEOC developments. This includes an opening chapter on the Supreme Court's religious accommodation decision that I just mentioned, and it also covers key statistics, key settlements, and a whole host of issues in dealing with the EEOC. So let's start off with a brief discussion in terms of development at the commission itself. First of all, in terms of leadership, we're going through some minor transition right now. You'll see the commission always has 5 commissioners, at least from a regulatory perspective, but one of the 5 commissioners, Keith Sunderling, his term officially expired July 1 of 2024. There's always a 60-day holdover period, but Commissioner Sunderling has announced that he will be leaving the commission by August. So we'll then be down to 4 commissioners, and as you will see, it essentially boils down to a 3-1 Democratic majority. What's interesting to note is that there's only been a Democratic majority since basically the last, essentially over the last year for all practical purposes, from November of 23 to basically essentially to July 23. Prior to that time, and particularly during the time period between November 22 and July 23, there were only 4 commissioners with an even split, so you didn't have a majority. And even more surprising, when the Biden administration began, they were in the unique position of having a 3-2 Republican majority on the commission. So we've been in a state of flux, but certainly with a 3-1 majority moving forward, you can expect certainly the possibility of additional things happening. Let's talk about the key reports of what you should be thinking about, what you should be looking at if you ever go to the EEOC's website, which is very easy to get to at EEOC.com. Certainly, the starting point that you need to look at is the most recent document focusing on strategy is their strategic plan, which was approved in August of 23. And you'll see the three objectives of having a systemic focus, outreach to educate the public, and just as importantly, strengthening the internal functions, including the effective use of technology. The real guts of what the Commission does, though, on an everyday basis is their strategic enforcement plan. And that really outlines the agency's key priorities. And we're going to talk about those over the next couple of minutes. Two other reports just to be concerned about or looking at and reviewing are the performance report and the general counsel report, which basically is sort of an internal report card, basically telling the public of all the things the agency has done. The general performance report talks about charge activity and litigation. The general counsel report focuses solely on litigation itself. As you will see in terms of the Strategic Enforcement Plan, or SEP as many call it, there are 6 basic priorities, which we'll talk about over these next 2 slides. And this is really at least the third Strategic Enforcement Plan where the basic priorities have remained similar. There have been some variations in terms of focus, but the basic 6 general priorities have remained the same. Certainly front and center has always been barriers in hiring and recruiting. This go-around, areas of focus are certainly background checks, exclusion from apprenticeship programs for those in the construction industry, and certainly sorts of exclusionary practices or the exclusionary impact based on the use of AI. Vulnerable workers, there has been this time around, there will continue to be a renewed focus on arrest and conviction records, LGBTQ issues, and unrepresented workers. Certain emerging issues you should be concerned with are improper qualification standards, pregnancy, which of course is front and center based on the recent statute and regulations, and AI. Backing it up in terms of the other 3 priorities, equal pay or pay equity is not going away. Preserving access to the legal system focuses on things like retaliation, releases, and what I'll call 3 areas of focus that the agency focuses on. They frown on confidentiality agreements, non-disparagement clauses, and arbitration agreements. And then front and center is harassment and systemic harassment, which we'll be talking about in our presentation today. In terms of the internal report card or performance report, we don't have time to go through all of these issues right now, and because, as I say, you will have the slides to take away. But 2 areas I'd like to focus on with respect to these slides is, 1, the success rate for EEOC mediation. The agency focused on the fact that 71% of the mediations that were handled through their mediation process ended up in resolution of those charges. The other thing you should focus on is the increased hiring by the agency. Due to COVID and other factors, we've seen quite a number of retirements and resignations, and believe it or not, over the last 2 years, there literally has been a 20% of the agency has been rehired, of new hires over the past year. So if you look back over the last 2 years, they essentially 1/3 of the EEOC workforce essentially is newer people, which includes frontline investigators and others. And I say that to you in the sense of if you are on the firing line and dealing with charge activity, sometimes you may be dealing with newer investigators who are going to be perhaps trying to show how aggressive they are because they may be new to the scene. So be prepared for that as opposed to dealing with what I'd call more seasoned investigators. The other part of the performance report I want you to be concerned about is systemic investigations and the whole systemic initiative by the agency. They resolved more than 370 systemic investigations over the past fiscal year. They've continued to focus on settling where they can, but they did file 25 new lawsuits this past fiscal year, which literally was more than double the number they had filed in prior years. So be careful. The agency continues to focus on this area, which could include, if it's one of the EEOC's priorities, and let's assume it's something like harassment and it's an individual charge, don't be surprised if they potentially may expand that into a systemic investigation. The same thing with hiring. If they're exclusionary policies or you're dealing with criminal background checks, don't be surprised if that is expanded into a systemic investigation. In terms of charge activity, and these next 6 slides, which we'll quickly go over, we really have the highest level of charges going up to 81,000, the highest level since 2017. Just as importantly, to the agency's chagrin, the backlog, or inventory as they like to call it, has also increased. So if you think about the level of charge activity of 81,000 charges, another 51,000 in their backlog, there are, over the past year, there basically have been 132,000 plus pending charges at the agency. So if they don't get back to you quickly after you file your position statement, don't be surprised, because that would be a contributing factor. In terms of litigation, we've also continued to see a spike. If you look at a comparison between 2022 and 2023, the fiscal years end in September 30th of each fiscal year. So we are now moving into essentially the last few months of the fiscal year. And one of the things that we have noted, literally going back at least over the past 5 to 6 years, literally I'd probably say 30% of the lawsuits are filed in the last 3 months of the fiscal year. So for example, last year, 60% of their lawsuits were filed in the last 2 months of the fiscal year. So it's astonishing what happens, but that's why if there's conciliation, there's enormous pressure to perhaps make their appropriate demands, and if they don't get what they want, they have a gun to your head, so to speak, with litigation threatening, and you will see an enormous number of press releases issued, particularly in that last month of September, where they're announcing all the lawsuits that are filed against the employer community. In terms of a breakdown of the lawsuits, interestingly enough, this covers all lawsuits themselves, but you can include obviously various types of claims, but fascinating that almost 40% of every lawsuit filed includes a retaliation claim. Interestingly enough, the big 3, aside from retaliation, have been sex discrimination, which includes a substantial number of harassment claims, and disability claims is right up there. So those are clearly been the top 3. In terms of the issues that have been front and center, certainly discharge, but right behind it, so to speak, almost 40% of the lawsuits involve some type of harassment claim, which includes sexual harassment as well as other types of harassment. In terms of systemic claims, as I mentioned before, if you look at a comparison between 21, 22, and 23, you'll see literally going back, not since basically 2018 have we seen as many systemic lawsuits, and I would not be surprised if we see a similar number for fiscal year 2024, but we're still waiting for those statistics as the fiscal year ends. So stay tuned, and we'll keep you apprised of developments. So let's move to the area of harassment. Front and center, new harassment guidance came out on April 29th. One of the things that I want to bring to your attention is that we literally are putting the finishing touches on a major publication that we will have for our clients and friends of the firm that discusses the recent guidance that came out. It also discusses the task force on harassment from some years ago, which focuses on harassment prevention. It talks about the number of lawsuits that are filed by the agency. So all of you following, today, probably next week, we should have that publication completed, and all of you will be sent a complimentary copy of that publication. And it is pretty meaty, but it's going to have a lot of food for thought for you. So that's why, as we go through this next few slides on harassment, I'm going to go through that relatively quickly, because you're going to have the benefit of a detailed and comprehensive discussion of this topic. What you'll see in this first slide is literally going back over the last 5 years, literally more than a third of all charges have involved charges of harassment. Just as importantly, on the right-hand side, 35% of all lawsuits filed in fiscal year 2023 involved some form of claim of harassment. The next development, and this was actually mentioned in the harassment guidance that came out, and part of the reasons for coming out with the harassment guidance, there has truly been, surprisingly, regardless of the fact we've been talking about harassment for years, and one would think based on all the harassment training that goes on in the workplace, numerous states where there's required harassment training, most employers have harassment training, but we've seen a spike over the last 3 years in terms of the number of charges, and just as importantly, if you look at the monetary recovery for systemic claims. So it's out there. Please be careful. Now, those are all forms of harassment in terms of the types of claims. In terms of the sexual harassment claims are built into that. When it comes down to the guidance itself, what you will note is what the agency tried to do is basically provide one-stop shopping. So they basically took essentially 5 different guidance documents that they had used over the years. They've essentially put it all in one place, and it really sets forth the liability standards as well as, just as importantly, the scope of harassment claims based on various protected statuses. And so that is really what is front and center in the guidance that really was issued in the spring of 2024. And it also talks about some various other issues that we'll go through. But some areas that they do highlight in the guidance, they basically provide some 25 Q's and A's. They provide some general Q&As in terms of dealing with harassment. They have a fact sheet for small businesses. But the 2 most important documents we really want to encourage you to look at, and that are going to be discussed in detail in the publication that you will receive, is the Task Force on Harassment in the Workplace, because the focus of that document, in contrast to the EEOC's guidance that just came out, is harassment prevention. What sort of action should an employer be thinking about to reduce the risks of harassment charges and harassment litigation? And at the time of that report, they also came out with recommended practices. A couple years or a year later, they actually took an excerpt from those and expanded upon in terms of putting together some promising practices for harassment prevention. We've also included those promising practices in the appendix to the publication that you're going to be receiving. We're not going to go through the general liability standards, except to say they are for your reference. The key thing is the legal standards have not changed. All the guidance does is put it in one place as a gentle, and not so gentle, reminder for all of you in terms of what the liability standards are. Certainly, as you know, for supervisory harassment, if it's tied to some sort of adverse employment action, there's going to be strict liability. It's only a question of how much you're going to pay. If it's generally a hostile work environment, then there are affirmative defenses that are set forth as we've laid out here. And obviously, if it's non-supervisory personnel or third parties, that's a general negligence standard. In terms of the guidance itself, the basic theme of the task force report is harassment prevention. And they basically have used the theme that employers should seriously consider rebooting this whole area of workplace harassment. Go back and take a close look at the policies, see exactly how you're approaching it. And they really look at 3 basic areas: leadership and accountability, and that is certainly accountability in terms of 2 factors. 1, actions taken against those engaged in harassment, and just as importantly, your managers and supervisors who are on the firing line, actions that they should take to ensure that they're addressing harassment right from the get-go. In terms of policies and enforcement, the task force report has underscored that be careful about zero tolerance policies, because it's more nuanced than that. You really should be looking at the specific facts and circumstances, because the task force reports took the view that if you basically had a zero tolerance view, it means even a minor form of harassment could ultimately result in potential termination of someone. And if that were the view, the task force took the view that that may even discourage individuals from reporting harassment because they don't want to necessarily get someone fired. So you need to really, the punishment should fit the crime is the best way of putting it. And obviously the guidance also goes through the training, focusing more rather than straight compliance, focusing on issues like respectful workplaces and, just as importantly, bystander training. So now let's turn a page and get to the next area, dealing with standards for liability. And let me turn it over to my friend and colleague, Jim.
Sure. Thank you, Barry. As you mentioned earlier, Supreme Court has given us a bunch of gifts in the last couple of years in terms of case law, reversing prior cases, reinterpreting such. So we're going to talk a little bit about those today. The first case I'd like to talk about is a case called Muldrow, and that deals with the scope of what is actionable under Title VII. You know, we often hear it's an oft-quoted thing that, you know, Title VII is not a super personnel department, or mere slights and insults are not enough to state a claim. So for a very long time, you know, there's sort of been a quantum of harm. What level of harm is required before one can actually state a Title VII claim? Well, that case was, you know, called into question in a case called Muldrow, and starting with the premise that, you know, Title VII says you cannot discriminate with respect to terms and conditions or privileges of employment. You know, what does that mean? How far down does that reach? Certainly, I think we'd all agree things like hiring someone or not hiring them or firing them. You know, those are pretty significant actions. But there's been a lot of debate over the years as to, you know, sort of what is the level of harm that must be shown. And a number of courts limited the scope of adverse action to sort of the ultimate action, objectively tangible harm: hiring, giving leave, promoting, or compensation. You know, sort of the big four. But lots of other things sort of fell outside the scope of what was actionable. So Muldrow is a great and very interesting case. I often joke with folks, and I show my age when I say, if anyone remembers Charlie's Angels, the opening of that show, they'd have about the three women who graduated at the top of the police academy and then were each assigned very important jobs like switchboard operator and crosswalk guard. This is a little bit what the Muldrow case is like. In Muldrow, we had a police officer who was heading the Department on Public Corruption, very high profile, worked with the FBI on high profile cases. She was plain clothes. She had the use of a weekend car that she could, you know, take with her on the weekends. Generally, you know, a fairly what I would call, you know, prominent, significant position. Well, quite literally, a new sheriff comes into town and says, I don't think I want Mrs. Muldrow, or Ms. Muldrow, he made a point of that, to be this person anymore. We're going to transfer her over to, you know, precinct 123, where she basically had to wear a uniform, no longer had her weekends off. She lost the use of the, you know, the weekend car. But importantly, there was no diminution in rank. She was not demoted, and she didn't lose any pay, and, you know, her no salary. So she brought a claim of sex discrimination, and in the lower court and up through the circuit court, they held that really she had not shown significant harm sufficient to state a Title VII claim. You know, they kept saying, you didn't lose any pay, you didn't lose any benefits, you didn't lose any rank. You know, what's the big deal here? And that's been, you know, we've seen this in the past. The courts have sort of strictly interpreted those ultimate employment decisions, such that, for example, we had a case where, you know, the employer forced employees of color to work outdoors without access to water, but white employees didn't have to do that. And the court said, no, you know, that's not enough. This is not about hiring or firing. Similarly, there was a case down in the Fifth Circuit, Hamilton versus Dallas County, where they said, you know, yes, men were allowed to select full weekends off. This had to do with the penitentiary. Men could take full weekends off. Female officers never had that option. They had to work weekend shifts. Again, no difference in pay, no difference in benefits. Well, up until it reached the, you know, sort of en banc in the Fifth Circuit, the court said, well, yeah, you know, we don't love the way this smells, but we're bound by prior precedent, and these employees are not stating enough of a claim. That ultimately got flipped when the full panel of the court said, nope, reading the very strict language of Title VII, these folks are certainly stating a claim of some harm. Similarly, District of Columbia Circuit 2022, starting to look very closely at the text of the statute and say, hey, looking back to a case called Bostock, which had to do with LGBT coverage under Title VII, they said, discrimination means discrimination. If you are treating someone differently because of their protected category, excuse me, that never fails to happen. If you're discriminating someone because of their protected category, it is in fact discrimination. So what happens next? Supreme Court took the Muldrow case where the lower court had said, no loss of salary, no loss of pay, that's not enough. And the Supreme Court said, no, we're reversing that. We do think that Sergeant Muldrow has shown sufficient harm to state a claim under Title VII. Now, they did not establish, basically they said it does not limit it to significant or serious harm. It's not limited to substantial harm. There is no sort of quantum or threshold of harm that must be shown. What they told us is that to state a claim under Title VII, you must show some harm, quote unquote, some harm. And I think Justice Alito in his concurring opinion said, I have absolutely no idea what this standard means. And I can say I am in full concurrence with Justice Alito. I think none of us really do in terms of what is this going to mean going forward, in terms of what is that level of harm. I mean, someone looks at me funny. I don't think that's enough to state a Title VII claim, but plainly I no longer have to wait until I'm severely and pervasively harassed or I lose my job or things of that sort. So we are in a sort of a bold new world, and we'll talk about this again with respect to another case later on in the program. But really, we're all now trying to figure out what is the scope of this decision? How broadly will it be interpreted? Muldrow is a Title VII case, but most of the statutes, the ADA, the ADEA, have very similar language. The cognate statutes have very similar sort of modes of what needs to be shown. So I predict, without knowing for certain, that this is not going to be limited to Title VII, nor I have the question of, is this going to be limited to only decisions about transfer, discriminatory transfer or shift setting? And I think very plainly it's not going to be. I think we're going to figure out in each of these contexts what exactly that it means. And particularly where I think it's going to become interesting is as we turn to DEI, or literally we call them IED initiatives, but what is going to be the scope of Muldrow with respect to some of these DEI initiatives, particularly things where you may have mentorship programs or scholarship programs or certain affinity groups, things of that sort. Traditionally, I don't think anyone would be able to state a claim by saying, my employer has this affinity group but not that affinity group. Likely would not be enough, but I'm not so sure that that's going to be the case going forward. I think the contours of that remain to be seen. Prior to the term, the Supreme Court decided Students for Fair Admission versus Harvard. Now, that is an education case. It's a Title IX. It's not a Title VII case. But many, many people, the case held that you cannot have affirmative action. You cannot take race into consideration in terms of college admissions. Many folks have, I think, persuasively argued that the language in Title VII is nearly identical. I think given the current makeup of the court, it is just a matter of time before they do hold and extend that holding from fair admissions versus Harvard into the employment context. And what is that going to mean for DEI programs? And here it's interesting. We see a little bit of an internal battle, I would say, at the EEOC. Immediately after the Harvard decision came down in June of 2023, EEOC Chair Burroughs, who's still the chair, issued a statement that basically said, no, nothing to see here. It's still lawful to have diversity, equity, and inclusion programs, accountability programs. We've all agreed for a long time that you certainly can't have quotas or preferences. You can't sort of use something to tip the scale. But the question is now going to become, what can you do, or what are the limits going to be? And certainly, I think maybe as a defensive move right out of the box, EEOC Chair Burroughs said, we don't see Harvard, the admissions case, the affirmative action case, significantly changing what employers can do. I'm not sure that all of her co-commissioners agree with her. I know that at least one of them has brought a number of charges relating to corporate DEI programs. And again, where does this start? We start with the language of Title VII. You cannot treat someone differently because of their race, color, religion, sex. We've seen, going back to 1976, reverse discrimination claims and things of that sort. We have the concept of affirmative action out there. A lot of it has still been called into question. EEOC has issued guidance, but literally most of it goes back to the late 70s, early 80s. They do maintain the position that Title VII permits diversity efforts designed to open up opportunities. Again, I think that's a noble statement. It's unclear to me what that is going to mean going forward, because even the EEOC, and this is back in 2006, said, employers are cautioned to be very careful implementation of affirmative action and diversity programs. So you really need to be minding your P's and Q's here, because again, I think the landscape is changing. There's a regulation on the books in Title VII that says a voluntary affirmative action plan may be permissible if you have a manifest imbalance, you're correcting the results of prior discrimination. I can say this, I was chief of staff to acting chair Victoria Lipnick when she was chairing the EEOC, and she said it publicly, so I feel comfortable quoting her. In all of her time, and she was at the agency for more than 10 years, never once saw one of these voluntary affirmative action programs in the private sector, not relating to OFCCP and government contractors. So it's out there on the books, but I think a lot of us are now starting to question the validity. Are we still able to do this? And it's important to note that, this is not, I would say, this is not a one-off case that the Supreme Court decided, and, no, it's kind of, for lack of a better word, non-intentional, or, oh, that's interesting, let's see where it goes. There has been a very concerted effort on the part of some to really limit the consideration of race. And I put someone up there, the American First Legal is one of these foundations that have filed dozens of complaints with the EEOC. You can often file on behalf of someone who's alleged victim of discrimination. There have been commissioner charges filed, but they are actively pushing the agency to move forward in this area and to really to limit what employers can do in the DEI space. It's a good time to look at, I think one of the questions that came in from one of our questioners is, do we think if there's a change in administration, depending on what happens with the elections in November, do we think if the administration changes that we'd see a different focus? Are there going to be different focuses of EEOC? And I personally think that there will. It may be a little slow to happen because there will still be that imbalance of 3 Democrats and 1 Republican. It'll be a while before the commission gets a Republican majority, much as it went through the Biden administration with a Republican majority. It took them 3 years to get a Democratic majority. It may take a little bit longer for a Republican administration to get a majority, but they will have a Republican chair. And I do think there's going to be significant pressure on the agency to do more in this space. I put a case up on the board there. Most recently, it's called Fearless Fund Management. It was a Black female-owned investment firm that invests in business. They had a contest, give us your best business ideas, and they were awarding $20,000 grants. Well, back in June, the 11th Circuit fell. It wasn't a Title VII case, but they held that a program like this is in fact unlawful under Section 1981, which prohibits discrimination on the basis of making contracts. So I would say, the shape of the law is shifting here rather quickly. I think EEOC is trying to maintain its position and maintain its ground. Certainly, they've been filing amicus briefs in cases that are raising these issues, including, whether unconscious bias or implicit bias training is per se discrimination. And the EEOC takes the position that an implicit bias training is not per se discriminatory, but depending on the contents, depending on what is contained in the training, and this is where I say in my time I've seen good training and I've seen not so good training. The not so good training may run afoul of that. Similarly, with respect to what employers can do in terms of voluntary actions, again, EEOC is going to seek to take the broadest position possible. But I think what's going to happen is we will see how this. I'm waiting to see if my slide comes up here. Here she goes, before we switch it back to Barry. But I think the takeaway is everyone should be taking a close look to the extent you're engaged in DE&I efforts. Now more than ever, you want to make sure they are nuanced. You want to make sure you are hewing to the law that's applicable, recognizing that the law is changing at a very, very rapid pace. So I'll be back to talk to you more about yet another Supreme Court case that has thrown us for a loop, but that's later in the program. But now, Barry, I'm going to flip it back to you for start with the big 3 of pregnancy accommodation issues. There's a lot going on that front.
Absolutely. I think the only thing I would add to what you just commented on, Jim, is there is an organization that's been challenging a number of the DEI programs known as America First Legal. The individual who's been the leader in that organization was very active in the Trump administration. So certainly, I think those issues are going to be front and center and subject to various challenges. So I think we need to stay tuned depending on the outcome of the election. But just I certainly think if there were a change, I think we have to anticipate there may be some pushback on DEI type programs.
I
All right, so
agree with
now
you. And
let's
before
turn. Yeah. So it
I was
sounded
just
like
going
you
to say,
agree, Jim.
I did agree. I'm sorry, we're tripping over each other, but I was going to say for those listeners who are participants who are government contractors, we saw in the first administration of then President Trump that they used the power the federal government has through federal contracting and procurement to try to issue a number of executive orders that dramatically limited things like bias training and such. I predict if there is a second Trump administration, we would see a lot of the same issues, and those are particularly sensitive for those employers who are government contractors. And with that, I mean at this time, I'm turning it to you, Barry.
All right. So, you know, it's interesting when you talk about the big three issues of accommodation: pregnancy, disabilities, and religion. Everyone, another term for accommodation is preferential treatment, because as you know, when it gets down to the law is supposed to be treating everyone the same. If you're dealing with the protected status in one of these three areas, you're really treating them differently and giving them a certain level of favorable treatment based on the accommodations that you're going to be making for them. So that, you know, just something to keep in mind when you think about it from a practical perspective. And let's turn, and again, the slides have a tendency to move slowly as we go through this, but the newest wrinkle is the Pregnancy Workers Fairness Act. As many of you know, that new law went into effect on June 27th of 2023, and then regulations were issued by the EEOC on April 19th after a long period of time for comment, and those regulations actually went into effect on June 18th of 2024. So what's new about this law? What I find, from at least from an employer's perspective, you need to be concerned about. When we always think about accommodation, we always use typically the ADA as the basic framework, and the whole idea of the framework is you have to accommodate someone absent undue hardship in order to make reasonable accommodations so that person can perform the essential functions of the job. The Pregnancy Workers Fairness Act has literally turned that concept on its head. And certainly your time and attention should be placed on the last bullet, which we underscored, because when it gets down to pregnant workers and those with, really we'll talk about pregnancy and childbirth and related medical conditions, the act and the regulations essentially take the view, even assuming someone cannot perform the essential functions of the job, that should not prevent accommodation. And meaning if it's inability to perform an essential function for a temporary period, and they're going to be able to perform them in the near future, and it can be reasonably accommodated, the statute and the regulations say you're required to do that. Now, the regs and so forth provide a little more flesh to the bone of what is meant by all of this. And what we tried to do is we took the very detailed regulations, and we tried to put them in plain English. And so again, you'll have these slides to take away with you, so we will go through this relatively quickly. But we came up with what I'd call 7 basic questions and answers that you can and should be asking yourself in terms of what do you do in terms of compliance. In terms of coverage, it's real broad. Pregnancy, childbirth, and related medical conditions. And that includes use of birth controls, lactation, potential pregnancy, past pregnancy, obviously current pregnancy, menstruation, infertility, fertility treatments, and certainly the big one, which has been most controversial, choosing or not choosing to have an abortion. That particular provision has been subject to challenge, and certainly in federal court in Louisiana, that portion of the statute has been blocked for Louisiana and Mississippi. But I think for right now, that will continue to be an area of focus or concern of whether those provisions, that particular provision, will be enforceable. Is there a threshold requirement before you have to accommodate? There's really no level of specific severity that is required in terms of mandating the accommodation requirements you're supposed to engage in. Now, here's the kicker: adding flesh to the bone in terms of what's meant by the type of accommodation when people cannot perform the essential functions. The idea for if you're dealing with pregnancy, how long do you have to do it? From the start, basically a period of generally 40 weeks. where you have to be able to accommodate that individual. If it's other medical conditions or someone is coming back following their pregnancy, following childbirth, then it's to be evaluated on a case-by-case basis. How does an employee request a reasonable accommodation? Verbally or in writing, and there it certainly mimics what's required under the ADA. How should an employer respond to a request for an accommodation? I mean, the bottom line is don't delay. Consider requesting an accommodation, granting that accommodation on an interim basis. They also have blanket exclusions in requesting supporting documentation in numerous instances. Now, certainly they don't want you to burden that individual with requesting medical documentation. You certainly can in some circumstances, but certainly when it's one of the 4 predictable assessments dealing with accommodation, dealing with pregnancy, or it deals with accommodation, please be careful because you can't even request accommodations. And looking at the next slide, if it will turn for me, the following 4 accommodations are needing to essentially accommodate a pregnant worker. That is, allowing an employee to keep water or drink, allowing an employee to take additional restroom breaks, allowing employees work that requires standing to sit or vice versa, or allowing an employee to take breaks as needed to eat and drink. You cannot require documentation before you grant those types of accommodations. So they're based on the regulations, they're very protective of pregnant workers. Obviously, a whole host of other accommodations on the right-hand side. You can take a look at those at your leisure. In many respects, they are comparable to some of the things you're required to do under the ADA and perhaps some more. What are some of the express unlawful practices? The couple things that really stand out is, one, any unnecessary delay. You've got to be really careful about delaying granting the accommodation, and just as importantly, requiring an employee to take leave when other accommodations can be provided. And of course, the anti-retaliation provisions also are in effect for this particular statute. So certainly, the agency is looking very, very carefully at this area. I mean, I've got some matters right now where we have some systemic claims that have evolved at the agency. I'm involved in conciliation right now. So please be careful because the agency is looking at this area very, very closely. In terms of the ADA, here too, it has not gone away. And dealing with the types of issues that come up, you can have a whole host of issues dealing with ADA issues, but reasonable accommodation, as you can see, is front and center 3/4 of the time. That's the issue that is in play. The 3 big issues: telecommuting, maximum leave policies, and reassignment. In terms of telecommuting, I think all of us know what happened during COVID. People were working back at home. Now we've evolved into hybrid workplaces for many of us. And so if in fact employees have successfully been able to work at home, for you to say that they cannot do it at home, unless it's truly a customer-facing type of job, you're going to be hard-pressed. And remember, even the judges themselves and their clerks work from home during the pandemic. So this area and even the case law in this area may continue to evolve. So please be careful in this particular area. The largest settlement in fiscal year 23 was $8 million. And that one of the key issues, and really 2 key issues, were maximum leave policies, meaning you're out for 6 months and you can only be out for 6 months. And if you're out longer, you're fired, or we will not maintain your leave. You've got to look at every one of these cases on an individualized basis, particularly when you're dealing with a disability, and engage in that interactive process and document accordingly. The other real tough issue is reassignments. This area continues to be litigated in the courts, but the real question is if someone cannot do their job with reasonable accommodation, do you have to consider transferring them to another available job that they can do? And the question is, if they are minimally qualified in jurisdictions like the 7th Circuit in Illinois, you've got to give them the job. In some other jurisdictions, you can still hire the best qualified individual, and that person is to be considered. But the agency takes the view, if someone is minimally qualified, they can't do their other job, you've got to put them in that position. So this is an area that continues to be litigated by the agency. That's just something you need to be concerned about. So let's move to the third prong, dealing with religious accommodation, and I'll turn it back over to my friend, Mr. Paretti.
Thank you, Barry. Yeah, religious accommodation. We have about 3 topics we're going to cover in the next 10 minutes, but I'd like to focus particularly on this one. I mentioned earlier the Supreme Court has just been, sort of the gift that keeps on giving. Well, they gave again in the context of religious accommodations and what an employer needs to do, what it needs to do in terms of accommodating an employee's religious belief or practice, and also what an employer can, has to show to not accommodate. So, by way of background, we all are very familiar with the Americans with Disabilities Act. You have to provide certain accommodations, but if they become an undue hardship, the employer is no longer required to do that. Well, the standard under the ADA has traditionally been a very difficult standard to meet. It required, significant expense, significant difficulty, such to the point that in my prior life, I used to say any, a major big employer is going to have a very difficult time establishing undue hardship under the ADA because they are so big, because they have the resources. Well, in contrast, under the religious accommodations requirements of Title VII, the standard had been a very, very low standard, a de minimis standard. So then comes along the DeGraff case. So we'll talk about the case. I want to just go through the facts because I think they're interesting, and then sort of what we think it means going from there. So in DeGraff, Mr. DeGraff was a postal service worker. He was, I think, a manager of sorts. For the longest time, he had a position where he was not required to work on Sundays. We all remember when the post office didn't deliver on Sundays. Well, over the years, the post office entered into contracts with private providers to sort of be that last mile carrier, such that the post office was now in the business of delivering on Sundays. And Mr. Groff got told, we recognize you haven't had to do this in the past, but times they are changing, and you are now going to be required to take some of these Sunday shifts. He said, I can't do that. My religion, as a part of my religion, I have to keep the Sabbath. I have to keep the day of rest. I can't do it. And for a long time, the Postal Service did what they could to accommodate him. He'd been working in one branch. They put him in another branch. They allowed for voluntary swap shifts and things of that sort. But ultimately, there came a point, I think it was first they had moved him from a big branch, which was doing Sunday deliveries, to a smaller branch that did not have yet Sunday delivery, and that was worked for a while. But then even the small branch got into the Sunday delivery game. And there came a point where shift swaps will someone volunteer to take the shift? There was only one other supervisor who was, able to do it. It became untenable, and the Postal Service gradually disciplined Mr. Groff. Ultimately, he resigned when it was, clear he was heading towards being terminated for discipline for those Sundays. Post office said, hey, we should not have had to accommodate him under this, de minimis standard that the courts had for years. We shouldn't have to do that. Well, the Supreme Court saw it a little bit differently. They said that they were, quote unquote, clarifying nearly 50 years of precedent, particularly a case that was established back in 1977 called TWA versus Hartstein, where the court had established that de minimis standard. And the de minimis standard was basically if you could show any increased cost or maybe inconvenience or morale suffering among employees, that may well be enough to meet the standard under for denying an accommodation. The Supreme Court said no, it is not a de minimis framework. They said we are not adopting the super high ADA standard, but we're adopting something that seems a lot closer to it. So again, substantial increased cost in relation to conduct. So what remains to be seen is what does that mean and how do we measure that? For example, the U.S. Postal Service is a very big employer. You might say if you look at the whole post office, they should have been able to find, wouldn't be such a big deal for them to get someone to work those Sunday shifts on an overtime basis or such. But when you look down to the unit, it was a very, very small rural post office in which he worked. There just wasn't that sort of availability. It was a tiny little operation. So are we looking at the whole company or are we looking at a part of the company? What are the size and operating costs? What are the nature of the accommodations that are required? So the takeaway is we know we are no longer operating with that very employer-friendly de minimis standard. I think, and it's going to have to be established in case law, that we are working with something that is much closer to the ADA standard, but questions abound. There's a number of cases that have applied Groff so far, but frankly, most of them have been in the context of COVID vaccination programs and mandatory vaccinations and religious accommodations. We have not yet seen many cases that get to, actual dollars and cents. It's going to cost me X. Is that enough? We also haven't seen the cases where we start to see, conflict between religious employers, religious employees and non-religious employees. We have a case where someone said, hey, so-and-so, the assistant signs off on all of her emails with, have a blessed day, or, her signature block says Jesus is the light. As a non-Christian person, that's very offensive to me. I'd like you to stop doing that. Tell her to stop doing it, employer. I think under prior precedent, the employer would have been in a very good position to say to the religious employee, hey, we've had complaints. You need to take that out of your signature block. We can't be responsible for, potential hostile work environment. I think now under Groff, the situation is a little bit different. I think the employer would have to show certainly more than just, we got a complaint from one disgruntled employee, or, it's a sort of speculative concern about employee morale. So things about what the standard means when you get to intangibles, as well as, again, we just have not yet seen what I would say the quantum of dollars and cents. What does one need to show? So what is my takeaway? As always, I try to give a little practical advice. Make sure your folks, we're all very comfortable with ADA. We've done disability accommodation for years. We now have pregnancy, as Barry talked about, and religion, which have both sort of raised the bar. So make sure that your folks understand we are no longer in a world where ADA is in one lane and all the other ones are in another lane. They're now really all in a very, very similar space. So we should be paying more attention than ever to religious accommodation requests, particularly insofar as coming out of the pandemic. I think most of the folks we surveyed have certainly seen an increase in the number of requests for religious accommodation. I think in the past there used to be the occasional one-off of, oh, I can't work a day, or, oh, I need a waiver of address requirement. We're now seeing it increasingly, and I think unsurprisingly, people have become aware of their rights, or what they believe their rights to be. So I told you 2 more things to cover in the little bit of time that we have. I want to talk briefly about artificial intelligence. EEOC gets into the game on AI as a matter of, are these tools, are artificial intelligence tools being used to discriminate? And you might say, well, what do we do? Where do I use artificial intelligence tools? Most often it's in the hiring context. If you use a program or have an algorithm that sort of sorts and ranks resumes, you get 5,000 resumes for one job. The computer says, hey, here are the top 20 candidates you should call back. The other 4,900 or 4,980 get thrown out the window. EEOC is taking a very close look at those as to whether the bias, whether the computer, the algorithm that's used does in fact have an adverse impact on protected categories. So over the past couple of years, they've had a hearing, they've done a few technical assistance documents. I don't think any of them have broken bold new ground, but as Barry mentioned earlier, it's recognized in the strategic enforcement plan. They've had a couple of cases, but frankly, most of them have not yet been what I would call true AI cases. There was one with sort of an intentional discrimination. We used a computer program that said, don't hire people over the age of blank. That obviously the fact that it was a computer program did not save the employer from that, but that wasn't really what we're talking about more broadly, where the concern is, and we are starting to see the charges coming, that these automatic decision-making systems may perpetuate existing bias, depending on how the data was validated, how the data was trained. There's not a lot of guidance on what is permissible. What we have goes back to literally 1978 in the Uniform Guidelines. So I think EEOC has started to become active in this area. I know Commissioner Sonderling, Republican, who was leaving the commission, he was very involved with this. I imagine someone will pick up the mantle in the next term, but it is an area where I'm telling folks, just keep an eye, know what you are doing with respect to some of these AI tools, and make sure HR knows and legal knows, because often we find that sales is doing something, but no one told HR or legal, and that can be a problem. Final issue I want to touch on very briefly, pay equity. Obviously, this remains an issue for the EEOC, again, in their strategic plan. They've a number of lawsuits pursuing pay discrimination claims. Equal pay data has been sort of very important outreach for them and focus. We obviously have all the states that have gotten into the act, but staying with the EEOC, I think most significant is we're all sort of waiting to see, is the EEOC going to come back and require compensation data reporting? For those of you who are involved with filing your company's EEO-1s, you'll recall that during the Obama administration, they expanded the form to include not only information about job titles and race and gender and ethnicity, but also rates of pay and hours worked broken out by race and gender and ethnicity and all of those things. The EEOC has indicated on their regulatory agenda that they intend to do something in this space by way of notice and comment rulemaking. It is already the middle of July. I don't think it's likely they're going to get something together for the next cycle, but we'll see. It takes a process, but they certainly have publicly stated that their intention is to do something that would again require this sort of pay data reporting. Whether it looks exactly like what they did in 2016 or whether it's something different, that remains to be seen. And again, I will predict that if there is a change in administration, to the extent the agency has started to go down this road, we may again see a change back towards that. So with that, we are on the hour, but I will give it back to our host, Stephanie, if she has any closing remarks. And thank you all for your time and patience. We threw a lot of material at you. The slides will be in your hand. You'll have links to all of this. Please feel free to take a deeper dive. We covered as much as we can in as little time as we had.
And
Tim and
before
Barry,
she jumps
thank you
in,
both.
Yeah, I think I'll add just one comment, and that is Jim and I both have a tendency to try to get as much in as possible, so we got it done within the hour just because we do speak quickly. This type of session could easily be 2 to 3 hours, so we packed it all in, but we thank you for your time, and let me turn it back over to our coordinator.
Tim and Barry, thank you both so much for providing us with this insider's view of the EEOC. Holy cow, there are so many updates and things to consider in employment law. It seems like it's never-ending changes. For those of you who are still in attendance with us today, thank you for taking the time out of your day to join us for this event. Hopefully you found the information helpful and it will help you prepare your compliance strategy so that you may remain in compliance. If you're interested in learning more, a survey will pop up on your screen. You may have to exit full screen mode to see it. Again, this is if you'd like to receive a complimentary demo of the Navigator Suite, which offers resources for employee handbooks, independent contractor classification, employee overtime exemption evaluation, and many other HR compliance topics. If that sounds like something that you're interested in, please select yes, and our team will reach out within the next day or so. Otherwise, we really do appreciate the time that you spent with us today, and we hope you have a great rest of your afternoon.